It's in this matter.
And then we will hear Mr. Venugopal.
Venugopal.
Yes.
I would take half an hour, my lords.
Certainly.
Only half an hour.
Yes.
In the 21st century, Millers, we are looking at issues of equality, inequality, issues relating to how we ameliorate the conditions of those who have been sidelined for centuries, who have been humiliated for centuries, who have been ostracized for centuries. I don't think we can ever imagine how they were dealt with in the context of the caste structure that prevailed. So, Millers, I think that the constitution makers in 1950 realized this. That is why the notification was issued in 1950. And they also realized that this is not going to stop, because they gave the power to Parliament, but this is an evolving situation. They gave power to Parliament to deal with the matter, and it's unlikely that this is going to end very soon. It is in that context, Millers, that we must look at this matter. And what we can do, quite apart from reservation. For Millers, the two basic assumptions that Chanaya made, which were wrong, is number one, they considered the scheduled castes in the order as a homogeneous group. They assumed that this represents a homogeneous group. And I will demonstrate to your lordships that that assumption is based on no factual data. That assumption is based on no analysis of that data.
What they hold is that once they find the place in that particular group, then they are all part.
Homogeneous. What's the basis of that? In fact, heterogeneity is inherent in that.
Actually, the homogeneous nature of all the entries is for the purpose of designation.
Yes, absolutely.
They are homogeneous in the sense that each one of them is a scheduled caste. But your argument is that there is no homogeneity either in terms of the sociological profile, economic development,
Correct.
Social advancement, educational advancement.
Absolutely. So that assumption in Chanaya was wrong.
Common factor is social and social backwardness, social and economic backwardness. But the degree may vary from one entity to another entity.
Absolutely. So the assumption of homogeneity in Chanaya itself is constitutionally flawed. That's the first mistake Chanaya made. The second mistake Chanaya made was that it correlated the presidential order with reservation. These are the two assumptions on the basis of which Chanaya was rendered. Neither of these assumptions is valid.
Because the designation is for the purposes of the Constitution.
That's correct.
It's not only for reservation, nor is it coterminous with reservation.
I'll go a step further. It has nothing to do with reservation. But that's the designation of this class has nothing to do with reservation. Reservation emanates from the plenary power of Parliament, which is in 16(4) for the purposes of employment.
Because Indra Swani says that it can be done even by executive instructions.
But now not anymore, Millers. Because now it's Parliament has to make a law, Millers.
What?
Now Parliament has to make a law to change the schedule,
Reservation, Indra Swani goes on to say that it is not necessary that there has to be legislation. It can be done even by executive instructions.
Maybe so, Millers, but that is not part of the notification. But that's nothing to do with reservation. My point is, Millers, you are assuming
that may not be correct, because if there is a reservation for scheduled caste, so unless that particular entry finds in the place in the presidential order, that person that is not entitled.
I just demonstrate that, your lordships, wherever they wanted to give reservations, they have given it. Then reservation is part of 16.4 itself as far as employment is concerned.
It's a necessary but not a sufficient condition.
Correct.
Designation under Article 341 is a necessary condition for reservation, but it is not sufficient in itself.
Correct.
Because having been designated, there is still an enabling power which is conferred upon the parliament, or for that matter, as brother says, on the executive.
Yes, but it's the union or the parliament, Malas, but the order itself has no reference to reservation, and I'll show that from the chapter itself. Malas, first of all, let me go to the first point, and then I'll come to the second point. These are two assumptions I want to deal with immediately. Now, kindly come to PDF. This is volume 4, 1386. Running page is 1381, volume 4. I'll quickly, demonstrate that here also. So, volume 4, page 1386, PDF 1386.
Volume 4, right?
Yes, volume 4, 1386.
Yes.
You have that chart now, Malas?
Yes.
So, Pela means snakes.
One has nothing to do with the other. Look at Malas, Bazigar. He indulges in acrobatic feats. Then Batwal Malas. Actually belongs to the Rajput caste. Malas is normally a watchman. So what you have an agglomeration of various castes which are put together who have been humiliated for centuries. The heterogeneity is clear from the table itself. I can go on, Malas. There is one Gagra, which has only 268 families in Jagraon in Ludhiana. There is a Nut, which is an unskilled labor. The Koli is the hunter and a butcher. The Sasi Malas is a criminal, comes from that class.
Kori would be fishermen.
No, but originally came as hunters and butchers. That is item Malas.
So there is heterogeneity
91.
in terms of the pre-existing occupation.
That's right.
In terms of the resources or lack of resources.
Exactly.
In terms, therefore, of all the indicators of backwardness or development.
Exactly. So therefore, they are put in one class.
Social status.
Yeah.
The status of every caste may not be the same in the social hierarchy as well.
Exactly. So that
between them, some may be a little more advanced, some may be a little less advanced, people may be particularly underprivileged.
Correct. Absolutely.
In terms of other indicators like infant mortality, maternal mortality, fertility rates, which sort of define, broadly speaking, whether there has been progress in the social indicators.
Absolutely. Now that assumption was made by a observation of Justice Krishna Iyer in Thomas. May I read it, Manas?
Yes.
We may clear the clog of Article 16.2 as it stems from a confusion about caste in the terminology of scheduled castes and scheduled tribes. This latter expression has been defined in 341 and 342. A bare reading brings out the quintessential concept that there are no castes in the Hindu fold, but an amalgamation of castes, races, groups, tribes, communities, or parts thereof found on investigation to be the lowliest and in the need of massive state aid and notified as such by the president. To confuse this backwardmost social composition with caste is to commit a constitutional error, misled by a compendious appellation. So that to protect Harijans is not to produce prejudice any caste, but to promote citizen solidarity.
In fact, by using the expression, this mixed bag,
yes,
the learned judge is really underscoring the heterogeneity of the
Exactly.
Then in the latter part, he says, but as a large backward group,
That's correct.
deserving of societal compassion.
Correct. Now, this is quoted by Justice Hegde and comes to the conclusion that it forms a class. Now, kindly have a look at that. PDF 796, volume 5.
It's 796.
Yes, volume 5.
Para
23.
The way of doing it is that not to deny that they form a class, but they form a class for the purpose of Article 341.
That's right. Absolutely.
So they may be a class for certain purposes, they may not be a class for all purposes.
That's correct.
Basically what you said in your submission.
There is a level of, what should I say, discrimination which runs through this entire list. But their vocations may be different, their historical way they were treated may be different, there may be so many differences. The numbers may be different. The extent of discrimination also may be different. Level of discrimination may be different. For example, Malas, what we are dealing with are Majbi Sikhs and Dalit Sikhs, Malas. Now, do you know what the origin of this is? The origin of this, what is the origin of Majbi Sikhs? Guru Tegh Bahadur Malas, his body was mutilated. And he brought that body to Guru Gobind Singh. And he was a chamar. The person who brought that body was a chamar. So Guru Gobind Singh took him in his fold. And therefore the chamars became part of the Sikh community. Now what has that got to do with this list? That's the historical context. Yes, Mazhabi means faithful.
There is also an entry with regard to chamars.
Yes.
In Punjab.
That's right. And that's why, Malas, your lordships find that the 32% of the population of Punjab,
It's very completely.
32% of the population is Dalits. More than any other state in this country. So now, Malas, just come to this volume, PDF 796 of the same volume, paragraph 23, where he quotes, Malas, the learned judge quotes Justice Krishna Iyer. That's the 135 that I read to your lordship.
Para?
135.
No, para 23, where he quotes 135, which I've read to your lordships. And then he says in para 24, the learned judge, according to Justice Krishna Iyer, though there are no castes, races, groups, tribes, communities, or parts thereof in Hinduism, the president on investigation, having found some of the communities within the amalgam as being lowliest and in need of massive state aid, including them in one class called the scheduled caste. The secretary thereof is that the scheduled castes are one class for the purposes of the Constitution. So I've demonstrated heterogeneity. I've demonstrated, Mullahs, that the basis of the judgment is that there is homogeneity. That assumption is wrong. The president may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the castes, races, or tribes, or parts of or groups within castes, races, or tribes, which shall, for the purposes of the Constitution, be deemed to be scheduled castes in relation to that state or union territory, as the case may be. Heterogeneity is writ large in 341 itself. Because 2 says Parliament may by law include or exclude. Till such time as Parliament passes, it's deemed to be. No state government, no central government can tinker with it after the presidential order. So that, just to answer that question that arose. Now, let's come to the second point that I was arguing.
Yes.
Namely, that this has nothing to do with reservation. Now, kindly come, brothers, with the greatest respect, kindly come to the chapter. How it starts. Special provisions relating to certain classes. That's chapter, part 16. Now, your lordships will find in this chapter, wherever the Constitution wanted to provide reservations, it said so. I'm not saying that the union government cannot ensure that there are... That's not the point, Mullah. That power the union has, that power Parliament has, that's not an issue.
16.4 doesn't refer to reservation.
16.4 does. I'll show, Mullah. That also is a misreading of 16.4. I'll show that presently, Mullah. Just allow me to take this.
330 expressly says reservation.
Yes. Reservation of seats for scheduled castes, scheduled tribes in the House of the People. Kindly come to 331, 333, 2. Reservation of seats for scheduled in the Legislative Assembly. Then come with us to 334, reservation of seats and special representation to cease after certain period. 335, claims of scheduled castes and scheduled to services and posts. And then, Malas, your lordship comes to the National Commission for Scheduled Castes, which is 338, which does this exercise. Because that recommendation is sent to Parliament. Parliament then decides whether to exclude or include. That applies thereafter to National Commission for Scheduled Tribes. And then your lordships will see for the backward classes, 338, 38B. And then you come to Scheduled Caste 341. So the scheme of the Constitution is clear. 341 is meant to identify the heterogeneity of those communities and castes and tribes who have been dehumanized over centuries. The power of reservation, your lordships will find in 16.4.
Mr. Sibal, in any state, is there any reservation under Article 330 specifying the communities which have been included in scheduled caste based upon their population ratio or something like that? No.
No, I don't think so.
Like Valmiki's 5 seats out of a total of 100 seats coming for.
So in Parliament, it's only for either scheduled caste or scheduled tribe.
That's all. That's all.
But then there can also be sub-classification in that also.
There is none. There should not be either, Malas.
Why?
For the simple reason, Malas, the representation of the caste to take forward.
I think as a matter of fact,
yes.
Insofar as parliamentary elections are concerned, even a scheduled caste from Punjab can contest in Maharashtra.
That's correct.
Against the scheduled caste.
That's correct. That's correct. Because when we're talking of reservations, we are talking about education and employment, not representation. Quay classes, quay different. Your lordship is right, but the problem there is, they can contest, each one of them.
For appointment is.
No, they can contest, Malas. They're not prohibited from contesting. So that's what the privilege is only to contest. That's the reason why.
A higher population will always succeed.
That's true. That may be true.
Of a community which has very little.
Hopefully, Mother, that situation will not rise.
Therefore, there was a debate.
Yes.
In the Constitution, because Dr. Ambedkar, prior to Pune Pact,
absolutely,
he wanted reserved seats specifically.
That's right.
Then ultimately, Gandhiji went on a hunger strike and
reserved.
Therefore, it was reversed. It was reversed.
And electorate.
Yes, it was reversed. So if you look at 16, Malas, something very interesting emerges. First of all, Malas, let me tell your lordship the difference between 15.4 and 16. Kindly read 15.4 with me. You will find no mention
Reservations.
of reservations.
It's special measures.
Special measures for advancement. This is important.
That's right.
Nothing in article. Malas, let me read the whole. The state shall not discriminate against any citizen on grounds of religion, caste, sex, etc. No citizen shall on grounds of religion, caste, race, caste, sex, place of birth, or any, have, with regard to access to shops, public restaurants, hotels, places of public entertainment, or the use of wells, tanks, bathing ghats, roads, places of... Now, Malas, these special provisions under 341 can relate to this.
That's what the learned AJ argued, that and Mr. Farasat also, that Chennai, they failed to consider interplay between 341 and 16.4.
But I'm not on 16.4. In fact, I'm going to make a distinction between 15.4 and 16.
But 15.4 may also comprehend reservations as well.
It does, Malaysia, it does.
The concept of special provisions for advancement
would include.
is broader than just reservations.
I agree, but I'm just only saying
Advancement
advancement.
postulates a quota, while a special provision may be quota plus.
Exactly.
It could be relaxation,
Exactly. In other
scholarships,
words,
anything.
The reason why I'm saying this, the reason why I'm...
54 was brought because it was held by this court that there can't be a reservation.
That's right.
In 51.
They struck down community-based reservation. Champakam Durai Rajan.
Miller, there's a reason why I'm making this submission, Millers, for your lordships to consider, Millers. And that is, there is a symbiotic relationship between 15 and 16. You reach 16 only when you are empowered under 15. If you're not educated, you can't get employment. It's simple as that. I'm talking about in the larger context, Malas. We're talking about 21st century, Malas. We're talking about the 21st century, Malas. Of course, some of them can,
The same
some of us,
14, 15, 16.
some of us can hold the highest positions in the country without being. So that's another matter, Malas. Some of us, Malas, have reached corporations, Malas, and managed corporations without necessarily being fully educated. That's not the point. The point is, Malas, there is when you're talking about this section of society, there's a symbiotic relationship.
We must recognize that the Constitution is not prescribing qualifications such as property, education, gender. This was an article of faith.
Yes.
And it was a very visionary provision because ours was one of the first constitutions which did not make your right to contest an election or to hold electoral office conditional on
I agree entirely.
conditional on gender or property or your educational qualification.
I'm with you on that. I'm arguing something different. What I'm saying is if this class of people that you call a class, if you don't empower them under 15, you're not going to get representation under 16.
So in that sense, 15, as you said, they share a symbiotic relationship because unless you create the foundation for employment,
right,
you not get employment. You need a qualified workforce to be.
It's only in that
limited workforce in the first place.
It's in that limited sense that I'm talking about this. That's all. Nothing more than that. Nothing more than that. Now, if you look at 16.4 now in this context, it doesn't also talk about scheduled caste, scheduled tribes. But if you go to 16.4a, it talks of scheduled caste, scheduled tribes.
The judgment of this.
That's right. So if you are not included in 16.4, how do you get reservation and promotions? 16.4 has to include scheduled caste, scheduled tribes because they are backward. They come within the genus of backwardness. So 16.4 is an answer. 4A is an answer that 16.4 includes. Allows for advancement through various legislative or executive measures.
Reservation could be one of them.
Yes, reservation is one of them. And it's integral. I'm not
the
saying
universe is much wider.
Much wider. So therefore, I've given some of the... you have the Karnataka Scheduled Caste, Scheduled Tribe Prohibition of Transfer of Certain Lands Amendment Act. You have Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act. There are all kinds of... You have the Protection of Civil Rights Act of 1955, all kinds. When we look at reservations, this will never end. This is an unending exercise that we are going through as a nation. The reason is very simple, Malas, that unless 15.4, unless you advance under 15.4, you'll not go to 16.4. So if you look at Malas Punjab, and I'm not going to the numericals of it, but the fact of the matter is that the total population of these is about 280,000. Government post is 280,000, approximately. I'm just giving you lordships.
Of Mazhabi Sikhs?
No, total government posts. The Mazhabi Sikhs and Dalits are about 32 lakhs. Total number of posts are 280,000. Out of that, Malas, 25,000 goes to scheduled. 25% goes to these classes, backward classes. Of the 25%, 50% comes to Mazhabi and Dalits.
Mazhabi and Valmiki.
And Valmikis. 50% come to Valmikis. Most of them are not even occupied. What does that tell you? And that's very important. I want your lordships to actually mention it.
That posts are not unoccupied.
Well, they will give you the data. Actually, I've asked the state.
Yeah, maybe there is no adequate representation insofar as Mazhabi Sikhs and Valmikis are concerned.
No, the others also. In fact, I've got some data, but I've asked the state, they'll give you the data. I've asked by this evening, we'll get that data.
Therefore, your point that unless there is educational advancement under 15 and social advancement.
That's right.
16 remains teasing.
Get better. There'll be cases after cases on the same issue for times to come. And if you can have Kasturba Gandhi schools for girls, why can't you have schools for Mazhabi Sikhs or these communities? Not just for everybody. That's the way forward for the nation. You don't empower them, and then you keep on fighting that there are not enough people in promotion.
Certainly.
Well, just one issue, Malas. Indira Sani, paragraph, note it, Malas, please. PDF 689, paragraph 778.
Just one second.
Yes.
Indira Sani, volume?
volume 5, page EFK 689, paragraph 778, they explain as to why in 16.4 the word class is used and not caste. They explain. I just read it. Indeed, there is a very good reason why the Constitution could not have used the expression caste or caste in 16.4, and why the word class was a natural choice in the context. The Constitution was meant for the entire country and for all time to come. Non-Hindu religions like Islam, Christianity, and Sikh did not recognize caste as such, though, as pointed out herein above, caste did exist even among those religions on various degrees. Further, a constitution is supposed to be a permanent document expected to last several centuries. It must surely have been envisaged that in future many classes may spring up answering the test of backwardness, requiring the protection of 16.4. It therefore follows that from the use of the word class in 16.4, it cannot be concluded. So therefore, the judges say the word class in 64, in our opinion, is used in the sense of social class and not in the sense.
We'll have a look.
It's antithetical.
Thank you, Mr.
I'm deeply.
Mr. Shankar Narayan?
No, we can't. There's others have to also argue.